Welcome to the Neufeld Legal Restaurant Business Law video series. My name is Christopher Neufeld and I'm a business lawyer with nearly 20 years of legal experience, with a strong emphasis on serving the highly challenging hospitality industry, from restaurants to bars, pubs, nightclubs, and such other food service businesses. In this particular video, we will be looking at key considerations associated with the legal structure when acquiring a restaurant business, namely whether the particular restaurant or bar should be acquired by way of a share sale or an asset sale. Acquiring a restaurant by way of a share purchase acquisition involves the buyer acquiring 100% of the target corporation's outstanding shares directly from the target corporation's shareholders. First, it requires unanimous approval of the target corporation's shareholders. All target corporation shareholders must sign the purchase agreement. Second, the target corporation becomes a wholly owned subsidiary of the buyer, or where ownership is assumed by the individuals become the immediate owners of the target corporation's shares. Third, because the target corporation becomes a subsidiary of the buyer effectively assumes responsibility for all of the target corporation's liabilities to third parties, including unknown liabilities. This means that, subject to any agreed price adjustments or indemnifications, the seller gets to walk away from any liabilities and the buyer takes them on. Fourth, there is no direct assignment of the target corporation's contracts or governmental permits. This may in turn reduce the likelihood that third-party consents may have to be obtained. Although some contracts and permits may require third-party consents with respect to change of control of the target corporation. Fifth, in a share purchase transaction, the target corporation's employees remain employed by the corporation unless a change of ownership triggers rights under the employment agreements of certain employees, such as senior executives. Therefore, unless the target corporation terminates certain employees and pays termination and/or severance pay before closing, the target corporation retains all of the employees, even those the buyer does not wish to employ. Sixth, assuming the proceeds from the sale exceed the adjusted cost base of the seller's shares, the proceeds of a share sale are taxed as capital gains, meaning only 50% is included as income. If certain conditions are met, the then current lifetime capital gains exemption is available to Canadian residents who sell shares of a qualified small business corporation. A corporate seller may be able to reduce its taxable gain by causing the target corporation to pay a non-taxable intercorporation dividend from safe income. That portion of retained earnings attributable to earnings reported for income tax purposes before the share sale transaction. The purchase price will be reduced accordingly. A buyer might prefer a share purchase transaction in order to take advantage of target corporation's non-capital tax loss carryforwards, for example, business losses, that can be applied against future income, subject to certain restrictions. A share purchase transaction allows the buyer to avoid paying sales and property transfer tax on purchased assets. These taxes can be significant in provinces that continue to impose a property transfer tax, such as Ontario, where the property transfer tax is 0.5% of the first $55,000 in value of real estate, 1% on the amount up to $250,000, 1.5% on the amount up to $400,000, 2% of the amount up to $2 million, and 2.5% on amounts after $2 million. Sales tax is dictated by the applicable province, ranging from 5% in Alberta to 13% in Ontario to 15% in the Maritimes, although an exemption may be available in respect to certain assets, such as production machinery and equipment. Seventh, generally a share purchase transaction is viewed as being less complex because there's only a transfer of shares from one party to another. However, the buyer will want additional due diligence performed on the target corporation to reduce risk and insulate itself with considerable legal protections in the share purchase agreement. Next, acquiring a restaurant by way of an asset purchase acquisition. This involves the buyer purchasing some or all of the target corporation's assets from the target corporation and may assume certain specific liabilities of the target corporation. First, an asset purchase may only require the approval of holders of the majority of outstanding target corporation shares, assuming the transaction involves the sale of all or substantially all of the corporation's assets. Although this is potentially subject to the incorporating jurisdiction's corporate laws and the potential of unanimous shareholders agreement amongst the target corporation's shareholders, overriding the majority rule requirement and shifting the decision to a supermajority or unanimous voting requirement. Second, the buyer does not assume responsibility for the target corporation's known or unknown liabilities, except to the extent that they are expressly assumed by the buyer or are imposed upon the buyer by law. The buyer therefore leaves behind those unwanted liabilities. However, by law, the buyer will become liable for environmental contamination and for union employees in an asset purchase transaction. Third, if the target corporation is financially distressed, transfers for less than the reasonable equivalent value may present fraudulent transfer issues under relevant federal and/or provincial laws, which have the potential to adversely impact the transaction and potentially have the negative consequences for the buyer. Fourth, an assignment of the target corporation's contracts and governmental permits may require third-party and governmental consents, and certain governmental permits may not be assignable. Fifth, in an asset purchase transaction, non-union employees need not be taken on by the buyer, though commonly the seller will require the buyer to offer new contracts to all or most employees on terms that are substantially similar or identical to their existing contracts, including a recognition of prior service, so the seller avoids wrongful dismissal claims from the employees. Sixth, on an asset purchase transaction, tax considerations are primarily related to how the purchase price is allocated amongst the various purchase assets. A seller will usually want the purchase price allocated to minimize the recapture of capital cost allowance previously deducted on depreciable property. The buyer will usually want to allocate as much of the purchase price as possible to depreciable property so that it can step up the value of assets to their fair value, resulting in higher tax deductions for depreciation expenses in the future. Furthermore, the buyer will be required to pay property transfer tax on real property and buildings, including permanently affixed equipment, if necessitated by the pertinent province, and sales tax on equipment and inventory, subject to any available exemptions. The buyer has the potential to take advantage of having higher future tax deductions from the capital cost allowance on depreciable property if the purchase price of the asset is higher than the undepreciated capital cost of the asset in the target corporation. For legal representation and effective legal counsel for your restaurant, bar, or hospitality business, from acquiring an existing restaurant or bar, taking on restaurant partners or financial investors, to franchising your successful restaurant to take your business model national and beyond, feel free to contact myself by telephone or email as set forth in this video or through our website www.restaurantlawyer.ca. Thank you.